You get fired, you go file your complaint for damages in another government jurisdiction and make your claim there for money, but you're not entitled to this position. And for another, there is no principled basis to maintain that pre-office misconduct can serve as grounds to be impeached, but not presidential removal for cause. That doesn't make any sense. So you could remove a judge for this? You could impeach a judge?
They missed the boat. On Wells Fargo. They fell asleep at the wheel on Silicon Valley Bank. Now Lisa Cook, who's been credibly accused of mortgage fraud, wants us all to believe she can stay in a seat, Dagan, to stop mortgage fraud.
Lisa Cook continues to struggle, now getting responded to by the DOJ in a very appropriate manner. We know that Lisa Cook has a difficult time understanding complicated documents. So the DOJ said, here you go, Lisa. We'll just put it into bullet points for you so you can read it, and Abby Lowell can help you understand it. So here is the case, of course, Lisa Cook versus Donald Trump. She says, I am entitled to my job. You can't fire me. Who do you think you are, the president? And Trump said, yeah, I am the president. I can fire you for cause because of mortgage fraud. And it creates at least the appearance of impropriety because you got 3 houses in a very short time period where you're clearly not signing them as primary residences. So she sued, and now we're in the District of Columbia. And this, of course, is Judge Gia Cobb who has this case, which is the nice little sorority sister for Lisa Cook, where they swear oaths and pledge to each other for the rest of their lives. All right, look, although Dr. Cook, they say, has now filed an additional 30 pages of briefing, she still remains unable to overcome multiple independent legal obstacles to the relief that she seeks and requests. Here's what they are in bullet points. Hopefully she can remember these. Dr. Cook fails to grapple with a century-old precedent that came from the Supreme Court. It's called removal for cause, and it happens as a matter of discretion of the president, and it is not reviewable. That's a 1901 Supreme Court case called Reagan versus the United States. Now, Cook tries to distract on this by citing different parts of the decision, but the court was clear. Substantive review of the president's for cause is wholly foreclosed. Otherwise, you're the president. Even if the president's finding of cause were reviewable, so they say, well, it's not, but even if it was, Dr. Cook still offers no tenable theory, has not even explained at all why apparent mortgage fraud does not qualify. She can urge that result only by reading into the statute words that Congress omitted using elsewhere, by pressing invented categorical rules that her counsel had already conceded away. And these categorical rules, remember, they came out, they're like, well, you can only fire her if she's been convicted of a felony involving financial fraud. Like, what? That's not what for cause means. You can only remove her if she murders a whole school bus. What? That's not cause. It's appearance of impropriety. She runs the Federal Reserve. We need it to not commit, have mortgage fraudsters on the board. Turning to procedure, Dr. Cook insists she was entitled to notice and an opportunity to be heard. Her due process claims, which she'll get as soon as she's indicted. No court has ever granted those protections to principal officers. Like, you need a trial before we remove you? Are you kidding? And regardless, is still unable to explain what further notice she would have wanted. She was notified appropriately on True Social with the rest of us. And what she would have wanted, or what she would have even told the president at a hearing. Would she have said, well, it's a clerical error. Sorry, Mr. President, I'm sorry. Here's my defense of your allegation. She hasn't even mentioned it. Now, all else aside, Dr. Cook continues to completely ignore the Supreme Court's twice repeated holding in disputes over whether federal officers have been validly removed. The balance of the equities favors the government, and it does not support her reinstatement because Trump was able to fire Boyle. Trump was able to fire Wilcox. Trump was able to fire Dellinger and many others. The bottom line is that the statute, Lisa, provides for the president to remove for cause. That's what it says. The president exercised that authority after public revelations of mortgage misconduct. And there is no basis in the statute, the Constitution, or the principles of equity for some district court judge sorority sister Gia Cobb to second guess that determination, let alone to order reinstatement. Now, at a minimum, Dr. Cook has not made a strong showing necessary to secure the extraordinary relief, which is putting a fired individual back into their position of power. Now, most of the arguments, writes Trump's DOJ, in Dr. Cook's reply brief were already rebutted. We've already dealt with this, but she just keeps crying about it with Abby. The president files this supplemental authority to address the new points and to cite some additional authority. Now, on the merits, Dr. Cook faces 2 insurmountable hurdles to her claim that the president lacked cause to remove her. Okay, 1, Supreme Court has already held. There is no judicial review for these things. You don't get to substitute your judgment for the president's when the statute clearly gives the president the discretion to make that decision. And second, the president had abundant cause for his action under any standard, no matter what it was, especially after accounting for deference interference and constitutional avoidance. And here's the case. It's called Reagan versus United States. It held that removals for cause that do not specify the causes that suffice are not subject for judicial review. If they said you can only remove for these causes or for causes like the following something, then you can consider those criteria. They didn't. That means cause, whatever it happens to be, is up to the discretion of the person who holds that power. A removal for cause, when causes are not defined, is a matter of discretion and it's not reviewable. And that rule squarely applies here, which she is trying to challenge. Now, Dr. Cook also fails to distinguish Reagan and to show why that case is bad. She says the provision in Reagan was really about for causes that are prescribed by law rather than just for cause. But actually, the act just says the Federal Reserve Act, which is illegal, merely provides for removal for cause. Okay, it doesn't say for causes prescribed by law. This happens all the time in the law. It's really sneaky. They just shove a couple words in there. But that cuts the other way. If the statute permits removal for causes prescribed by law, if it leaves the cause determination to the discretion of the appointing officer, the same goes for other statutes. Dr. Cook is also wrong to assert that Reagan and its non-reviewability holding, saying judges can't check these things, is only for offices without fixed terms, okay? So you can't fire the FBI director, give me a break. You can't fire the Federal Reserve Board, give me a break. They're all under the executive branch, and the president has the constitutional authority to do it. Now, in rejecting the petitioner's substantive challenge to his removal, the court in Reagan rested solely on the removal for cause. They said the law doesn't define it, and it has nothing to do with a fixed term. The precedent doesn't talk about a fixed term. It talks about cause, not cause unless you have a fixed term. Dr. Cook blurs the rationale for rejecting the substantive challenge with something the court said in rejecting a procedural challenge. Now, as to the latter, the court reasoned that notice and hearing are only required where causes of removal are specified by constitution or statute. Otherwise, it's cause. Now, the dictum about procedural protections for officers with fixed terms, again, because just think about it logically. Like if somebody comes in, she says it's mortgage fraud, it's not a big deal. I think it is because she's on the board of the governors of the Federal Reserve. So it's pretty important for her to have financial propriety and not even a smidgen of an appearance of impropriety in that position. And that is cause. Now, her contrary theory also makes no sense. There is no reason to think that Trump's discretionary determination of what constitute cause is any more amenable to judicial review, simply because she's got a fixed term. And again, this is mortgage fraud, but what happens if she embezzled $1 billion? And you'd say, well, that's definitely for cause, because they're saying that this is not for cause, right? And it's not their decision to make that. Well, this is more serious than that. It's not their decision. Trump can make that decision. If they don't like it, they can impeach him or pass a statute. Congress doesn't have to sit there. They can pass a statute or do something about it. But just think about it. If she embezzles $1 billion and you can't fire her, it's like, what? That doesn't make any logical sense. Or you can only fire her after the 14 years are up. Or you can only fire her after she's had notice and a hearing and all of these other things. And so the Federal Reserve has to have this allegedly corrupt individual on the board wrecking the sanctity of that body. Why would the executive branch want to have that go on for 6 months, a year, while she goes through her appeals and all those things? You get fired, you go file your complaint for damages in another government jurisdiction and make your claim there for money, but you're not entitled to this position. They say this is also a non sequitur. The DC Circuit has confirmed as much by holding a fixed term of office is a ceiling. It's not a floor on the length of the service. And so a fixed term doesn't give you any removal protections. It's already been decided, 1897. And also, they explained why Marbury versus Madison, the seminal case that establishes judicial review, is not holding differently. Now, other cases actually corroborate Reagan. President Cleveland removed the Justice of the Peace under a statute authorizing removal for cause. The DC Supreme Court said you can't review that. You can't determine the sufficiency of the causes. You're not the president. You don't get to say that's good enough. Okay. Likewise, the Supreme Court of Colorado said the same thing. New Jersey said the same thing. And even treatises, a treatise here that was written in 1892 from Montgomery Thropp, he said the same. So Dr. Cook, instead, she points to nothing that calls this long-established doctrine into question. And indeed, she ignores entirely that modern Supreme Court precedent has further shielded the president's discretionary determinations. Dalton versus Specter, president can fire people. Instead, Dr. Cook says, judicial review must be available. Otherwise, Congress and their restrictions are dead letter. But that doesn't follow. As these other cases illustrate, not every vague standard that the legislature imposes is subject to enforcement by the judiciary. And finally, Dr. Cook also cites legislative history, which is usually a pretty bad strategy. She says, well, Congress contemplated that members of the board would be independent. Now, justices, of course, are not subject to removal by the president, right? For cause or otherwise. That's a check. The executive can't remove the judges, only Congress, which is why we were screaming about this yesterday. They are only removable through impeachment. Had Congress wanted the governors of the Federal Reserve to be equally protected, just like judges, they would have said so, but they didn't. Now, even if it were reviewable, there's no basis to disturb Trump's decision. To repeat here, what happened? Let's be clear. It's fraud. A senior financial regulator made flatly inconsistent representations in important financial documents shortly before taking office, so she could go gobble up a bunch of properties before the scrutiny came upon her. Okay, it was a corrupt process in addition to being fraudulent just on the sake of, getting a lower mortgage rate. Like, that is obviously a problem. But in addition, she was buying all these things up knowing she's going to this board. Treating that as cause for removal is hardly a clear-cut abuse of discretion, warranting judicial intervention. And it does not somehow mean that the president has more power to remove other Federal Reserve members than other agencies. It's the same. Removal restrictions applicable to the latter officials are unconstitutional, meaning Article 2 empowers the president to remove them at will. You can't limit the presidential power. And so this court doesn't need to wade in. Is the Federal Reserve exempt from that rule? We didn't have to go into, we would like this to escalate, to be honest with you. I'd like Jerome to be fired. I'd like this to go to the Supreme Court and have them say the Federal Reserve Act, which created a pseudo-independent body outside of our three branches, is unconstitutional. I'd like to see that. But we don't have to get there, is what they're saying, because the law says it's for cause, and we can just get rid of them for cause. Now, this court doesn't even need to go into it. Now, Dr. Cook, again, she says, well, for cause means only inefficiency, neglect of duty, or malfeasance. Again, we think that committing mortgage fraud and continuing to profit from that fraudulent and corrupt contract is a perpetuation of the crime. That is malfeasance in office. So, Lisa, even according to your own standards, you passed the test. But she is quickly forced to concede. The Supreme Court rejected that reading previously. And so her second escape hatch, she's struggling, is that conduct before taking office could not amount to cause because she did it before she came in. So the fact that she committed all of her frauds in anticipation of getting the job immunizes her. As long as you get in, you're good. Notably, her counsel affirmatively abandoned that claim at the hearing. Abby said, well, we're not taking that absolute position. That concession was prudent. For one thing, nothing in the text even hints that cause is limited to conduct in office. Now, malfeasance in office that they made up says that, but that's not what the law says. And for another, there is no principled basis to maintain that pre-office misconduct can serve as grounds to be impeached, but not presidential removal for cause. That doesn't make any sense. So you could remove a judge for this? You could impeach a judge? For a third, even the state court cases that she cites, they recognize that pre-office conduct can be cause for removal. Because if it is rendering that person unfit to serve, they can't be there. That's exactly what President Trump did. And there is no second basis for a court to second guess it. And relatedly, Dr. Cook, she also distorts our response to a hypothetical at last week's hearing. She says that her mortgage misconduct was not a valid cause because it was already long known to the government. They already had these records and they didn't do anything. Now, she did not make that claim in her complaint or her opening motion, and so it's therefore forfeited. But regardless, it is also wrong, right? She can't just shove new arguments in here. Now, while obscured by squirrely language, Dr. Cook does not say she ever provided the underlying mortgage documents to the White House or to the Senate. She says that only she identified both properties as subject to mortgage loans on her Form 278E and described one as her primary residence and another as a second home. But none of that is problematic. And like anyone else, she's free to seek a second mortgage on her home. But like anyone else, she could not misrepresent it as a second residence. And so she's not proving in any of her evidence here that the Senate was aware of her misconduct and confirmed her nonetheless. They didn't know about the misconduct. Like, she's like, well, I submitted the paperwork to you and you didn't catch me. I cheated on the test and I got it through. So you can't hold that against me because you're too dumb to catch my cheating. It doesn't make any legal difference. What are you talking about? Finally, Dr. Cook's pretext theory is also legally foreclosed and factually unsupported. She's saying Trump is specifically targeting me. Now, as to the facts, any idea that this is a pretext is baseless. Her only evidence is that the president has criticized the board over their policy. But the mere existence of a policy disagreement doesn't override any for-cause removals. You can have both. You can have a disagreement and for-cause removal. Just because it's like you can only remove people you agree with? Is that the rule? No. None of the president's statements about Federal Reserve policy made any mention of removing her. Indeed, the president can have disagreements and he can make those known. It doesn't immunize her from consequences of misconduct because the president disagrees with her agency. Now, her procedural challenge is also futile, just like the board. Dr. Cook's fallback procedural challenge is no better. There's no statutory right to a notice or hearing. Stop crying about due process. First of all, the Federal Reserve Act did not confer on her a right to notice in a hearing before removal. She's not on trial. The act provides no procedures requiring notice. It doesn't contain any processes in the act either. It says for cause. That's it. Not for cause, but you have to let them stay here in this position for 6 months while they flesh out their complaint. That stands in stark contrast to other statutes that expressly require notice and a hearing before a removal. For example, the National Labor Relations Board, they put in their statute upon notice and a hearing. And so Congress knows how to write words, so if they want to put it in there, they could do that. But Congress didn't. Congress has shown it knows how to adopt language. We have to presume that they're intelligent. They know how to write things. So I know it's a stretch, but courts have to believe that. Indeed, Congress demonstrated that they understood the bill. The original bill passed, and there was a debate about it. And the law is what it says. Now, Dr. Cook argues that the critical cases supporting her arguments are these two cases, but those cases are bad. Simply put, the key question, does the statute, does the law, does it give her a right to a notice and hearing? No, it doesn't. The answer is it is not a requirement. They didn't have to give her anything. She got plenty of notice on the True Social post like the rest of us. Now, her alternative theory is that she has a property interest. It's her position, which is obviously insane and anti-American. Dr. Cook discounts Taylor, and Taylor has already said public office is not property. It doesn't belong to you. You're not entitled to titles of nobility or whatever for the rest of your life, and all your further generations get to inherit your position in the Federal Reserve. Get out of here. She discounts Taylor because she says, well, that was about elected offices, but that's not how the court reasoned on any of this. One of the reference decisions which rejected a property right, she tries to distinguish, but she mischaracterizes the case. The Supreme Court's understanding is consistent, with the traditional view of state courts that offices in this country is not property. There is no vested right. It's wholly inconsistent with our system of government. We don't have indefinite kings. So then she points to Marbury versus Madison, and she says, well, there is judicial review, but she cites no case holding that any public officer, let alone, has a property interest that is subject to judicial review. It's not what it's for. It is impossible to conceive how, under our form of government, somebody could own a title to a government office. It's insane. It's not England. In any case, the procedures utilized here were sufficient to satisfy any materials. She says, I didn't get notice, but there is no real question that actual notice satisfies her rights. And she says, well, there were no specifics ever provided. She says, well, I didn't know why I'm getting fired. She says she identifies no facts that were unclear. Well, what didn't you understand? We said you got fired for mortgage fraud. What was so confusing to you? The referral attached to the agreements and their contradicting covenants, and they speak for themselves. The only missing fact is whether Dr. Cook acted intentionally or negligently. And that doesn't matter to for cause, because either way, it's bad. Like, oh, you're just an idiot? You can't fill out mortgage documents? So how can we trust you to look at complicated financial documents that relate to the safety of the country? We can't. So you're fired for cause. Now, on opportunity to be heard, she says that the president didn't invite her to push back on the charges, and the president's not obligated to do that. She says this lawsuit is not the place to make her case and more. But the factors here support denying Cook's motion. Last week's opposition brief explained that the orders in Wilcox and Boyle are binding precedent on the application. In both cases, they said that the government faces a risk of harm by having people shoved back in when the government doesn't want them there. That holding is binding, and it should apply here. And Dr. Cook doesn't distinguish it at all. All she wants you to do is just ignore those cases. Now, indeed, she cites Wilcox for a caveat where they actually did mention the Federal Reserve. But the Federal Reserve, they were only responding to an argument from somebody who was not in the Federal Reserve that there were greater protections in other agencies, saying, this is not crazy. Look, the Federal Reserve has protections. Look, over here has. So the Supreme Court was responding to that, saying, well, yeah, the Federal Reserve protections are different than you. They're distinguishing this person, Wilcox, from whatever position he was in, but that doesn't mean that the Supreme Court ruled on the Federal Reserve in that case. It wasn't even the subject of the case. So that question is not presented here, and it's very similar to the balance of the harms. The harms of allowing an officer removed for cause to be shoved back in creates more harm. Now, even looking at her irreparable harm, remember she said she also has reputational stigma for her. Yeah, mortgage fraud is not really that much of a reputational stigma. Instead, it's the fact that you got fired for it. Even looking at Dr. Cook's irreparable harm, her demand fails under the law. She tries to distinguish her situation by saying her removal, there it is, involves reputational and stigmatic harm. So she's unique and special, so she gets all of the protections against that. Anybody who gets fired has to deal with that. But those harms are attributable to the new revelations of her misconduct. It's not not unfair, not for her for-cause removal. Reinstatement would not erase the revelations and restore her reputation, and nor should it. The damage is done when she adamantly refuses to address the charges in any way. She could have responded, I didn't sign it. In any event, the law does not support a reputational exception. The only cases that she cites address the framework for at-will employees when they can bring due process challenges, but she's not being deprived of anything. Even assuming she was entitled to more process she received, it doesn't change the nature of the harm she's suffering. It's loss of employment, and that is not irreparable. Everybody, you can lose your jobs all the time. It doesn't mean you get to go sue somebody and say, you've caused me irreparable damage. You're fired. Society couldn't function if that was the standard. There is no other concrete harm that she is alleging. All of these are facially wrong. And so, indeed, if anything, an injunction reinstating Cook to office is even less warranted on her procedural claim. There's no basis for her having an opportunity to be heard or any of those things. And so, if the court, you, Judge Gia Cobb, sorority sister, if you have any doubts about the merits of this, you should deny this injunction based on the equities alone. In other words, you don't even have to reach like for cause or the constitutionality of the Federal Reserve. She's a mortgage fraudster, so it satisfies those things for sure. But in addition to that, just the act alone of putting somebody who was fired back into the position tilts the balance of equities in favor of the government. Just that fact. Doesn't matter what agency it is, doesn't matter what a Supreme Court has said, your remedy is you don't go back into the position of power. You go file your claim elsewhere and deal with it there. So they say the court should deny the requested relief in a very nice filing here from Jeremy S.B. Newman over at the DOJ, U.S. Department of Justice Civil Division. Very nice filing, and I think Lisa is cooked. So we'll see what she says. She wants a surreply, and the DOJ is objecting to this, but she says here, submitted another motion, Abby Lowell, we want to file a surreply. So we can respond to that, and we'll see if they do. But we've also got some conversation about this, and this is a great exchange and interview. This guy's name is, as we're going to find out, James Fishback. He runs a hedge fund, I believe, an investment fund, portfolio, some kind of a fund, and is a sharp dude who's been on this saying what Lisa Cook is doing is having an impact on the financial sector. I'm in the financial sector. I know, I can see it. And he's explaining how bad it is on with these Fox people. And also Fishback also submitted an amicus brief. Okay, so he's actually involved in the litigation as well.
Bailing people out when the shinola hits the fan.
That is exactly right, Dagan. There is not a problem the Federal Reserve has actually preemptively, proactively solved in the American economy.
What do they do?
They caused the housing bubble. They missed the boat. On Wells Fargo. They fell asleep at the wheel on Silicon Valley Bank. Now Lisa Cook, who's been credibly accused of mortgage fraud, wants us all to believe she can stay in a seat, Dagan, to stop mortgage fraud. Bill Pulte has said this time and again. This type of mortgage fraud undermines mortgage origination. We call it at Azoria the Lisa Cook tax. We did the math on this, Dagan. Because of the owner occupancy fraud that Lisa Cook committed, if you were to eliminate all of that in the entire housing market, you would actually lower mortgage rates by 14 basis points. That might not sound like a lot, but that's $17,000 over the life of a 30-year fixed rate mortgage. So to your point, I think the Federal Reserve gets far too much credit on the way up and far too little accountability on the way down. I wish we could stop talking about it, but I'm glad that the president has removed her. And make no mistake, she is fired. Larry is right.
Well, she's still sitting there, and I'm kind of waiting to see if...
And that's the question. Why is Jerome allowing that to happen? Maybe he should be fired too, and we can just duke this whole thing out right now and ask ourselves, why do we have the Federal Reserve? And what have they achieved for us by having this so-called independence outside and apart from the executive branch? And you might like that. You may not want the president to have control over fiscal and monetary policy or have any say-so in that. But isn't that important to our own self-governance? It's weird how we have like sort of democratic representation in many other areas of our governance, except fiscal and monetary policy. And however the American people want to vote, Trump comes in, he has a whole different vision for economic policy, monetary policy, fiscal responsibility. Shouldn't we have some accountability for those decisions so that the president can make some decisions and we can say, that was a bad idea. Holy crap. We might be going through that right now. We might fast forward 4 years and go, wow, tariffs, that was an interesting little experiment. But maybe it didn't work out. Or maybe it does, right? Maybe it works out beautifully well and we have a much more prosperous and less hollowed out country. But we would like to have some accountability, some skin in the game for those decisions, not just delegate all of this stuff out to some third party, fourth party, who's not even a lawful entity of our country and who enables mortgage fraudsters who cause all of our mortgages to go up. We got to pay more money because she's getting benefits. We're happy to see some accountability happening here, and we'll keep our eye on this one.